We have breaking news from Missouri tonight where the state attorney general, Chris Koster, has responded to my questions about the mistakes made by the assistant district attorneys who presented evidence to the grand jury that investigated the killing of Michael Brown. The Missouri attorney general says the police use of deadly force law in Missouri must be changed. In response to my question to the attorney general, he said, among the problems that Ferguson has brought to light is the need to update Missouri's use of deadly force statute. This statute is inconsistent with the United States Supreme Court's holding in Tennessee versus Garner. Consequently, it is important this statute is amended by the Missouri legislature to incorporate the Garner decision and to avoid confusion within the criminal justice system. As I have reported on this program, there should be no confusion in the criminal justice system because the United States Supreme Court clarified the proper and legal and constitutional use of deadly force by police in Tennessee v. Garner 29 years ago. I reported last week that the Assistant District Attorney, Atty. provided the grand jury with the wrong law on police use of deadly force, the Missouri law that was rendered unconstitutional by the Supreme Court decision in 1985. The grand jury transcript shows that Atty. handed all of the grand jurors a copy of the old unconstitutional Missouri law and said, it is the law on what is permissible, what force is permissible, and when in making an arrest by a police officer. But that wasn't true. That old unconstitutional version of the law said that it was legal for Darren Wilson to shoot and kill Michael Brown simply because Michael Brown at some point ran away from him. At the very end of the grand jury proceedings, Atty. corrected the record by handing the grand jurors a current copy of the law that included changes made to that law by the United States Supreme Court in 1985, when the court made it illegal and unconstitutional to shoot fleeing suspects simply because they were fleeing. When she handed them that law, Atty. did not explain to them what the difference was between the two versions of the law that she gave the grand jury weeks apart. For more detail on this, including all the relevant quotes from the grand jury transcript, you can go to our website, lastword.msnbc.com, to see all the reports I've done on this matter that provoked today's response from the Missouri Attorney General. We also got a response today from the district attorney's office that presented the evidence to that grand jury. We asked the district attorney the following questions. How many times has Atty. submitted the wrong law to a grand jury as its legal framework for an investigation? How many times has the district attorney's office in general, all of them, submitted the wrong law to a grand jury as its legal framework for its investigation? And is the Michael Brown case the first time, the very first time, the district attorney's office submitted the wrong law to a grand jury as the legal framework for its investigation? At first, we got no response from the district attorney's office. We asked for a response again yesterday, and today the district attorney said, quote, not at this time. Joining me now is Susan McGraw, a law professor at St. Louis University. And so, Professor McGraw, there's the district attorney saying at this time they cannot answer how many times they've given the wrong instructions, the wrong legal instructions to a grand jury. We have no idea how many times they've done that.
It's troubling. You know, this is the only time that that process has been recorded also. So this is the only time we would have any indication what goes on in these secret grand jury hearings.
Yeah, exactly. And I've been talking to lawyers in many states about this. They're all shocked to a person that this could possibly happen because it's such a simple law. And they all say that in their states, they can't conceive of it happening because case law, which is what the United States Supreme Court element of it is, case law is always included with the statutes. Legislatures don't go back and rewrite their laws every time the Supreme Court rules something unconstitutional, but what does happen is that case law gets physically attached in many cases to the statute when it's used in courtrooms and in any legal proceeding.
Yeah, there's no way if there was a jury trial that a judge who would monitor the proceedings and ensure that the law given to the jurors is correct would have allowed this mistake to happen. And it's really just a reminder that we're dependent upon the good judgment and goodwill of a prosecutor and a grand jury, because there's no judge there to ensure that the correct law is given or the correct procedure is followed.
And what's your reaction to the part in the grand jury transcript, both times, when she hands them the law in the first place, right before Darren Wilson's testimony, which is very favorable law to frame his testimony, and then at the very end, she hands them the correction, and she never explains to them what the difference is between those two documents?
That's very problematic. You know, I teach law school, and we spend a whole year teaching law students who have college education how to correctly read the laws contained in the statutes or jury instructions. These jurors, clearly, as reflected in their questions, were very confused about what the law was that they should follow, what law takes precedence. That one of them asked a question about United States Supreme law over Missouri law. So clearly they were very confused, and we're really trying to get more information, but it was not forthcoming.
What's your reaction to the Attorney General's response today, saying that it's time to actually change the statute, incorporate the case law right into the statute?
I think that's absolutely correct. It should have been done before this happened.
Susan McGraw, thank you very much for joining us tonight.